COBRA was founded at the first day. In fact, we commenced arrangements in the founding of COBRA the day after Ramaphosa declared the national lockdown. And it was immediately created by Engaged Business Turnaround and IQ Business. And since then, we now have in excess of 40 partners who've all joined to collaborate to provide pro bono services to businesses in distress. The services include a knowledge base on our COBRA website. You'll find that on www.cobra.org.za. We provide advice via email. Send an email to info@cobra.org.za and we'll provide the advice. We can set up a Zoom with you, your team, your employees to deal with any issues from a legal perspective, an accounting perspective, or have a look at our partners. I mean, we have professionals across the board. We assist small businesses, spas, shops. Tomorrow we have a webinar at 10 with Gigi Alcock dealing with those businesses all the way up to big businesses, and assistance is given at that level by IQ Business. So if part of the process is also providing pro bono webinars such as this one. So today we're dealing with business rescue in a nutshell. We're going to be going through the law on business rescue, but mindful of the fact that COBRA is not about business rescue. COBRA is about avoiding a business rescue by doing everything in our power to negotiate with creditors who may want to be paid, and a moratorium may be required, business rescue may be required, but only in instances where creditors are being unreasonable in relation to their claims. So what we do is we bring those creditors into COBRA and in turn their creditors, and we negotiate all the way up the ladder. So I'm going to kick off by asking Peter of Engaged Business Turnaround to take us through business rescue in a nutshell. We'll be diving into issues such as PCF, contracts, and sureties. After that, in more detail, he'll give a broad overview of the balance of the process. But before we do that, let me introduce my panelists. I have Ian Fleming. Ian is the CEO of Engaged Business Turnaround. Gary Barachowitz. Gary is Schindler's Attorneys. Tasneem Khan is also from Schindler's Attorneys. Renee Klopper is from IQ Business. Peter Gordon, he is from Engaged Business Turnaround. He's a business rescue practitioner himself. And Emma Marseille from IQ Business. So I'm going to hand over to you, Peter. Thanks so much.
Morning, everybody. Thank you, Maurice. Maurice used a very important word in his introduction there to business rescue, and that is the word moratorium. It is the fundamental cornerstone of Chapter 6 of the Companies Act, which was promulgated in 2011 in the 2008 Companies Act. And essentially what that moratorium does for a company or a CC, it's the only two legal entities that fall under this provision of the Act, obviously it's the Companies Act, is that nobody can bring legal action against the company whilst in business rescue. And when I say nobody, that's not only in regards of trying to recover debts that have remained unpaid, but any legal action whatsoever. The company we talk about, it has a steel jacket around it, it's completely protected. So what does that do? Well, it allows the company to utilize the time given, and I'll discuss the time limits in a minute, but the time given by the moratorium to sort out their affairs, try and restructure their balance sheet in whichever way is required. It is total freedom to use the assets and liabilities of the company to restructure it in whichever way. So what that means is that each business rescue is pretty unique. Each one of them is founded on the circumstances existing in the company. And it's under the auspices of the business rescue practitioner. Another important point, once going into rescue, the company has to appoint a practitioner who then stands in supervisory control of the board. Now, that has been abused in the past by some rescue practitioners, but certainly when Ian and I do rescues, we do quite a few together jointly, we always take a collaborative approach. There's little point in becoming antagonistic towards the directors. That's assuming, of course, the directors haven't perpetrated fraud, and we've had one or two of those in the past. But generally, we try and work with the directors to resolve the situation so that the creditors are better off than they would be in liquidation. Another important point. The practitioner is at every step of the way trying to beat what a liquidation payout would be, either through a controlled wind down of the business, so selling the assets in a controlled manner rather than in a forced sale, as would be the case in a liquidation scenario, or to get the company up and running again, restore it to financial viability and solvency, and hand it back to the directors stroke shareholders so that the company can go on into the future, and hopefully having achieved the goal of paying the creditors a better return than liquidation firstly, and then also importantly to make sure that jobs are being maintained, which was always a major factor when the Act was first promulgated. So how does one go into rescue? Very simple process. Excuse me, the directors take a resolution. They first discuss, is the company financially distressed? That's defined as the company is unable to pay its financial obligations as and when they fall due in the next 6 months, or in the next 6 months, the company believes that the liabilities of the company fairly valued will exceed the assets of the company fairly valued. If either of those are in existence, the directors then take the resolution to go into rescue. They then appoint one of their members to sign an affidavit on behalf of the company. Importantly, in the affidavit, the directors have to state that they believe that there is light at the end of the tunnel, that this company can be rescued, that this company can pay creditors more in rescue. It will be a better solution than going into liquidation. And if that exists, they file the resolution and the affidavit together with a form at CIPC, and the company is immediately in rescue. And immediately, I mean at the point at which the email is sent to CIPC, the company is in rescue. That's an important point, because very often this is a time-driven thing and one's trying to get it in before possibly an acrimonious liquidation application is made against the company. Importantly, if a liquidation application has been filed at court, then you can't go into rescue without resolving the liquidation, either through negotiation with the applicant or through an application to court to overturn the liquidation application. The latter is often done merely to delay the process. It isn't necessarily the preferred route, because, to be honest, the longer these things get delayed, people often say to us, when is it too late? Well, it's too late once it's been left too long. And that's the point at which the value that's inherent in the assets of the company has dissipated, and it's impossible to beat that liquidation valuation payout to creditors. In the process, the creditors are generally, or what we call the affected persons, that's mainly the creditors, also the staff and the shareholders, are in control of the process. However, the shareholders, and importantly so, only have a say in the rescue if the business rescue plan affects their rights. So possibly they had ordinary shares and we're converting those to preference shares, or we diluting their shareholding or whatever, then they have a vote on the plan. Otherwise, they have no vote on the plan. The creditors vote on the plan. In order to get a plan through, which the practitioner has to prepare and present within 25 days after his appointment, or an extended time if approved by the majority of creditors, he then presents his plan. He has a vote taken on it at a formal meeting. At that meeting, he requires 75% of those voting. Another important point, it's not all the creditors, it's only those that took the time out to vote, either in person or by proxy. And if 75% have said yes, subject to, of that 75%, 50% of the creditors who voted have got to be independent. Independent means they've got no connection with the company other than the fact that they're suppliers of product or services to the company or money. A non-independent would be a shareholder loan, an intercompany loan, etc. Pretty easy to define. If you reach that 75% hurdle, then the plan is adopted and it becomes the Bible. The business rescue practitioner then is tasked with implementing the plan. He or she can deviate from that slightly, without going back to the creditor body. But if there's a major change, so we thought we were going to rescue this company by handing a solvent company back, and we've realized that there was some skeletons in the cupboard, and we've had to go down the controlled wind down route, then we would go back to the creditors and explain that to them and get them to approve that. That approval would be a 50% plus one majority of creditors. Once the plan's implemented, the practitioner then files notice at Sub C that the plan is substantially, important word, you don't have to cross every T and dot every I, but as long as the practitioner is happy that the creditors will be paid out as per the plan, he can hand the company back to the directors and take the company out of business rescue. Maurice, I think that's it from our side on the high level.
Yeah, thank you very much, Peter. I did mention at the outset that COBRA is not about actual business rescue, statutory business rescue. We want to avoid business rescue, but the other statutory options that are available to you if you wish to enter into a compromise with creditors. There's a section in terms of our Companies Act, section 155, which deals with compromises. And I'll ask that Ian, please, if you can take us through section 155.
Thank you, Maurice. Right from the beginning of engaging with a distressed client, we're always trying to work out exactly what the correct legal framework is under which to move forward with the company. It's very important to get that right from the start, because business rescue is not always necessarily the right option. We need to consider, is it business as usual with some minor interventions from our side? Is it what we call an informal turnaround, which is a turnaround outside of the legal framework of business rescue, without the protection of business rescue? Is it a section 155 compromise? Is it a business rescue? And in the worst case scenario, is it perhaps a liquidation? Okay, so section 155 compromise, as Maurice has asked me to explain, is basically where a rescue practitioner or a turnaround practitioner will put together a rescue plan that envisages certain creditors taking what we call in layman's terms a haircut, or with the technical term is a compromise, that the amount owing to them gets compromised. And what will typically happen in the section 155 compromise is that the practitioner will work out the compromise, the extent to which each category of creditors will be compromised. In this case, we use the categories of creditors being secured creditors, preferent creditors, i.e. SARS and employees, and then concurrent creditors. So a section 155 compromise plan would typically say secured creditors are being compromised to the extent of 10%, say, preferent creditors are being compromised to the extent of 30%, and unsecured creditors are being compromised to the extent of 70%. It allows the company, the compromise has to allow the company to return to a solvent position from where it can then move forward and trade. And it is quite common for the turnaround practitioner to stay involved with the company after the compromise has been made in order of court in order to see the turnaround through. What the practitioner will typically do is then once he's put the plan together, he'll call all the creditors together, and each category of creditors has to vote in favor of the plan. And once again, it's a 75% majority by value who elect to exercise the vote that is required by each category of creditors in order to pass the compromise, in order for the compromise to be adopted. Now, that of course differentiates, or that differs from business rescue, where we just look at creditors as one class. It requires the business rescue, as Peter explained, requires 75% of all creditors to vote in favor of the plan and 50% of independent creditors to vote in favor of the plan. So in a section 155 compromise, once the meeting has been held, once everybody, with obviously normally some negotiation, as in a business rescue, which is one big negotiation process really, there's normally some negotiation in the 155 process, and once it's all agreed and each category of creditors has voted accordingly in favor of the plan, then the business rescue practitioner goes to, or the practitioner goes to court, has it made an order of court, and thereafter the compromise is in effect and can be, and the company can once again trade from a solvent position. One of the downsides of a 155 compromise is that it does not offer the company the legal protection that business rescue offers. In other words, while the practitioner is busy putting together the compromise plan and negotiating with creditors and so on, an aggressive creditor can then apply for liquidation of the company during that time. The legal protection is effectively only afforded in the 155 compromise when it is made an order of court, which is typically towards the end of the process. Maurice, I think that sums it up.
And I think that's the important take home, is that when it comes to 155, you don't have the moratorium. But on the question of the moratorium in the context of business rescue, there are some other very, very important take homes. And the first is that the moratorium does not apply to contractual obligations. Contractual obligations have to be suspended by the business rescue practitioner. And if they're not suspended by the business rescue practitioner, they continue to endure, which means that the counterparty to the agreement can still place the company in breach and cancel the agreement. So if one, in the context of a lease agreement, by way of example, if the business rescue practitioner does not suspend the lease agreement, the landlord can still terminate the lease in accordance with its terms, and the landlord can still evict. The moratorium will not assist. So the take home here is, if you're going to go into business rescue, and if you're going to be using practitioners outside of COBRA, please make sure that those practitioners are aware of their obligations and are aware of the fact that they have to, as soon as practically possible, suspend those agreements. Because if they don't, you could be evicted. So our suggestion is, put together a list of your creditors, put together a list of their details so that the business rescue practitioner can immediately notify them that the contracts are suspended. But not all contracts are suspended. Employment contracts in particular still continue to apply. And that's the case with the statutes, such as Section 189 of the Labour Relations Act, or the Labour Relations Act in general, also the Basic Conditions of Employment Act. Those still apply, those contracts still apply, and you still owe the very same obligations to your employees as you did pre-rescue. In fact, you have additional obligations post-rescue, because the employees are afforded further rights in terms of the provisions in the Companies Act dealing with rescue. So those contracts do not get suspended, and the employees have the very, very same rights as they did prior to rescue. Which means that if you want to vary an employee's salary, as has happened in the last 3 months, and we've seen it a lot, companies, they explain to their employees that they're in rescue and that that they're in distress, and that the only way that they'll be able to salvage the business is by reducing the wage bill. Now, you cannot simply impose that on the employees. You still have to follow Section 189 of the Labour Relations Act, which incidentally deals with dismissals based on operational requirements. So it begs the question, why would you look to that provision dealing with dismissals when all you want to do is vary employment terms? Reason being that the provision, Section 189, requires you to consult with employees if retrenchments are being contemplated. And your obligation to consult is set out there, and you have to consult on ways to avoid the dismissals, appropriate measures taken to avoid potential dismissals. And one of the measures that you'd put forward as part of that process is a reduction in salary. So you'd say in the 189 notice, we can save your job so long as you take a temporary reduction in salary. Then what will happen is the employee will have an election, either to accept a severance or to agree to the temporary reduction in salary. COBRA, we have specialists in labour. They're available on a pro bono basis to take you through that consultative process, to draft the notices, and to have professionals deal with your employees on an impartial basis. You know, what invariably happens in situations like this is the employees do not trust the employer. And the moment one intervenes with an impartial person, that trust is instilled, because the business rescue practitioner has no vested interest in being dishonest to their employees or pulling the wool over their eyes. So it really, really assists having an impartial person. So we urge you to use the services of COBRA. And if you think about it, why not? It's pro bono. You'll have seen that Mazepoli, a famous Greek restaurant chain, went into business rescue. I think it was yesterday, judgment had been handed down. And in that case, it was the employees who applied to put the company into business rescue because they were dissatisfied as to the manner in which the staff, the manner in which management was dealing with them. And the judge sided with Mazepoli's employees and said, business rescue is certainly appropriate, have an impartial person come in. So in that instance, it was actually the employees that asked that a business rescue practitioner intervene with a view to resolving the issues that they had faced. What we have seen in the past is benevolent business owners forking out cash of their own to pay any shortfall in staff salaries. Now, there's another extremely important take-home when it comes to lending the company money. So if you want to pay a shortfall in salaries, as a shareholder, you'd put the money in on loan account, or a lender would put the money in on by way of a loan, and that would cover the shortfall. But that is an instance when business rescue is appropriate, even in circumstances where there is no pressure by creditors. So I'm going to ask Peter to elaborate and provide us with more details in relation to post-commencement finance and pay particular attention to the preference it affords the lender. Over to you, Peter.
Maurice, thank you. Yes, very important point here. A shareholder lending money to a company, very common feature of privately held businesses, is at the point at which a business goes into rescue, is treated exactly the same way as any other unsecured creditor in the rescue. So those people that were owed money, including the shareholder on the day of rescue, are caught up in the business rescue plan and can only be paid in terms of the plan, rather. Now, what does that mean? Very often a plan includes a compromise. We've got creditors exceeding the assets of the business. It's impossible for the business to repay all the creditors. This is the case often certainly in a wind down, but very often in the case of trying to restore the company to solvency as well. Because whilst you're restoring a company to solvency, you can't trade the company for the next 20 years trying to pay back the creditors as at the rescue date. So there's always a cutoff point which makes it commercially feasible to resolve the issue with the creditors. So what does that mean? It means that the shareholder who put money in is going to get less back. Simple as that. We don't know what that number is until the business rescue plan has been produced, and that can range from anything above the liquidation value to 100 cents in the rand. Now, if there's a compromise, the shareholder then is obviously worse off than had he put the money, he or she, put the money in after the rescue date. Because anybody providing, as Maurice calls it, post-commencement finance, as defined in the Act, PCF as we call it, anybody putting PCF into the company is immediately preferred. The business rescue practitioner has to pay the PCF creditors before he can pay those that were in existence at the date of the rescue. So that means that you've got a far better chance of getting your money back. And the law had to be written in that way because nobody in their right mind would be throwing money at a company that was in distress if they didn't have some certainty of getting their money back. Importantly, the rescue practitioner can also use the unencumbered assets of the company as security for that money that's come in. So very common for a shareholder to put money in, or any other financial organization, to put money into the company and take, for example, a mortgage bond or a second mortgage bond over property, or some sort of security over the assets of the business, and then they become super preference. So if that company goes into liquidation, that credit has to be paid first. Obviously, if it's a second mortgage bond, then the bank or whoever holds the first mortgage bond would be the first, have first bite of the cherry for that particular asset, the proceeds from the sale of that property or whatever it was that was mortgaged. And the shareholder or the person that brought in this PCF would have the second bite of the cherry. So it is important, as Marie says, if the company is about to go into rescue, please do not put money in. And we've had it where people have said, I funded the salaries last week and now we've decided to go into rescue. Because by funding the salaries last week, that money's caught up in the rescue, and the shareholder or the provider of those funds is going to have to wait in line with the rest of the normally unsecured creditors to get paid. Maurice, back to you.
Yeah, thanks. Another aspect of post-commencement finance and where it becomes relevant would be in relation to suretyships. Now, when it comes to suretyships, you're the surety. You've stood as surety and co-principal debtor together with the principal debtor being the company. Now, you, in all probability, will be called upon to pay in terms of that suretyship. Bank will look to you. So if you can just deal with the question of post-commencement finance in the context of the law relating to suretyships. So the first obvious question is, what happens? What becomes of the moratorium apropos surety?
Maurice, an important point. There's about 5 questions that Ian and I have that we ask anybody that approaches us at the first meeting rather, to ascertain what the position is, and this is one of them. Have you signed personal suretyship in favor of the bank or anybody else? Quite often people forget that they've signed personal surety. You hired the photocopier from the Nashua, and Nashua has a last small print that by signing this, the shareholders or the directors offer up their personal sureties. Now, in the early days of rescue, what we were finding is that a lot of the banks had been a bit slower out of the blocks and hadn't been changing the terms of their suretyship, whereby they had to wait for the dividend, if any, that came out of the business rescue plan before they could pursue the giver of the suretyship for payment of the debt. That's changed quite dramatically, and virtually all bank loans now will state that essentially the giver of the surety, the shareholder normally, is jointly and individually responsible for the payment of that amount. So what that means is the bank can go after the company and they contact the company, and the company says, sorry for you, we're in business rescue. We haven't cancelled your security that you have from the company, but you're going to have to wait in line. As Marie says, it's all suspended. So important point there, the security isn't cancelled by the way of the moratorium, it's merely suspended. But then importantly, they say, well, that's fine, good and well. Now we're going to go after the shareholder stroke directors because they've issued personal suretyships to us. So the directors stroke shareholders are not, importantly, not protected by the moratorium. Now, what we do as a general practice is try and work with the banks. Obviously, we speak to all the banks, the units that deal with business rescue and recoveries. It's our part of our business expertise. So we do speak to those banks often, and what we will do is try and resolve the personal suretyship with the bank where the person that's issued the surety is fundamental to the operations of the business. The last thing we want is a director stroke shareholder that's constantly extremely anxious because he's at fear of losing his family home, for example, and therefore his attention's not on the detail of the business. So we would try and come up with an arrangement with the company, and we've done a couple of these in the past, not only with the banks, quite often a major supplier holds suretyship from the individuals. So it's a matter of negotiation, and if it's a fairly small amount that is owed, it's very often beneficial to the person that's issued the suretyship to put that money into the company to repay the debt, whatever it is. If it's the bank, repay the bank, remove them from the rescue, and the person that's put the money in takes over the rights and obligations of the bank. So they buy up the creditor, if you like. And in that way, they've resolved their personal surety, and they've also provided PCF into the business. So, but it is an important point. The other important thing to remember is, whilst this moratorium is there to protect the company, and I underline the word company, not the directors, not the shareholders. So any wrongdoing of the directors, reckless trading, etc., anything like that, any fraud, the directors can still be held liable for that. Maurice.
Yes, thanks for that. We dealt with labor, we dealt with the moratorium, and we've dealt with contracts, employment contracts in particular. But what I'd like to do is move over to Ian on the question of the practicalities in dealing with employees. So the question arises as to, upon a business rescue happening, what does the business rescue practitioner do? So practically, Ian, can you take us through that process?
Maurice, on the day the business rescue practitioner is appointed, from that, which has to happen 5 days after the company goes into business rescue. From then, he has, within 10 business days, he has to hold a meeting with all the creditors of the company, which is called the Section 147 meeting, and he has to hold a meeting with the employees or the employee representatives of the company, and that is called the Section 148 meeting. At that meeting, he will typically inform the employees as to any plans that might exist. The purpose of the meeting is for the business rescue practitioner to state whether he believes there's a reasonable prospect of rescuing the company. And at all times during the business rescue process, the practitioner has to keep asking himself the question, is there a reasonable prospect of at least giving creditors a better return than they would get in liquidation? Bearing in mind the purpose of business rescue, the original intended purpose of business rescue was to return the company to a solvent going concern, but then after that it became acceptable for business rescue practitioners to give creditors better return than in liquidation. But inevitably what happens in a business rescue is it normally ends up being a hybrid of the two. Certain sections of the business or assets will typically be sold off, and certain parts of the business will be returned to solvency. So the employees obviously want to know what the likelihood is of them retaining their jobs. So during that first meeting, the practitioner will typically give them an idea as to what he contemplates in terms of the retrenchment process. What's very interesting is the SAA judgment that came out in probably over a month ago now, where the business rescue practitioners were taken to task and taken to court by the unions because of the fact that they had commenced the business rescue process, that commenced the Section 189 retrenchment process during the business rescue prior to a plan having been published. And the Labour Court found that the business rescue practitioners should not commence the retrenchment process before a business rescue plan has been published. Now, the ruling is subject to appeal. The BRPs have taken it to the appeals court, so we await the outcome of that. But the practical implications of this ruling are that any time up to business rescue commencing, the company can commence the Section 189 retrenchment process. And then any time after the business rescue plan has been published and approved, then they can once again commence the Section 189 process. But between the company going into business rescue and the plan being published and approved, they cannot commence the Section 189 process. Now, a lot of business rescue practitioners are obviously not too happy about this because, for one thing, the time before publishing the plan can sometimes be quite an extensive amount of time as an SAA, and during that time they need to pay salaries, and they don't want to be in a position where they run out of money in order to be able to pay salaries. So you will notice that in the Edgar's business rescue, the practitioners managed to publish the plan within the 25 days, which we consider to be pretty impressive given the size of the rescue. And one of the main reasons for that is the fact that they wanted to get the Section 189 process underway. So when the business rescue plan is published, the plan will typically include the way that the business rescue practitioners see the Section 189 retrenchment process being played out. And the plan, as Peter explained, will obviously then be voted on, and once it is approved, then the Section 189 retrenchment process can commence. Thanks, Maurice.
Maurice,
Thanks,
could I just make a comment? It's an interesting point that Ian's just covered, the unintended consequences of the law. What we're going to find is a lot of practitioners are going to work damn hard to get their plans approved within the 25 days that Ian talked about. We do target that, and we try our damnedest to meet that timeline. But we have had rescues that have dragged on and on and on for a couple of years in some cases. And what this is going to do is, if there is a large labour force, the practitioner doesn't have the flexibility of doing a 189 reduction in staff without having filed, and it's importantly published a draft, so it doesn't have to have been voted on yet, but having published the draft plan. So I think we're going to see some vuma coming into some practitioners who are known for dragging their heels on getting their plans published. Just a thought, Maurice.
And on that score, Peter, Group 5, I don't know if you've seen the developments there, but 48 shareholders, I'm going to read, are seeking, amongst other things, that the court has set aside. It's quite interesting. They go back. The resolution adopted by the shareholders at an AGM held by the company on 7 November 2017, commencing the business rescue process, then the resolutions in relation to financial assistance that they want set aside, and then they want the guarantee provided by the company and Standard Bank set aside, and that the proceedings be converted into a liquidation. And they're doing that for the very reasons that we're actually dealing with now, that they're dissatisfied with the manner in which the business rescue practitioners are conducting themselves. I was wondering if you just want to comment on that in the context of the rights afforded to affected parties when they're dissatisfied.
Maurice, yes, look, I mean, anybody can approach the court. I'm getting an echo on here. I don't know if somebody's... anybody can approach the courts for relief if they believe something hasn't been properly dealt with. In fact, it's included in the 189, the section, the 129 rather, section on going into business rescue. If any of the deadlines, so you've got so many days to file the notice of rescue, you've got so many days to appoint the practitioner, you've got so many days for him to have the first meeting that Ian talked about with creditors and staff, and then so many days to publish the plan. If any of those dates are not met, the Act actually says that the rescue is a nullity. Now, we often have a slip because companies' records very often in this arena are not fully up to date, so we don't know who all the creditors are, and we send notices to all known creditors, and then we suddenly find that one or two were missed, and we'll get a threat from those creditors that they're going to have the plan have the rescue set aside, made a nullity. And of course, that's nonsense, because there have been court cases where the courts have overturned that and said that, the practitioner wasn't aware of them, and in that instance, it's been overturned. I haven't read up on the Group 5 situation. Group 5's got some very good practitioners running the rescue, so I've no doubt they've been extremely pedantic to make sure that they abide by the law of Group 5. I mean, it would be a hell of a thing to unwind. A lot of those Group 5 assets have been sold. Those would be binding sale agreements with third parties. Other construction companies have bought up some of their businesses, and this goes across the continent. It's just not in South Africa alone. So it would be a massive thing to unwind and to liquidate, because there are new owners in terms of the business rescue provisions of those assets. So I'm not too sure how the applicants have worked out that could be set aside. As I say, I don't know the detail of this particular case, but suffice to say, if there's any problem and We have had a number of these in COBRA where people have come to us and said, you know, we've had directors, we had a meeting the other night with directors saying we went into rescue and we've been told absolutely nothing. They weren't paid, they weren't allowed to vote. Remember, affected parties can vote. So anybody, the staff have a vote because they're creditors of the company. The fact that they've got unpaid leave pay, bonuses, and salaries for the period up until the point of rescue means that they are affected peoples, and they therefore have a vote in the plan. So, you know, people get abused, I have to say. And on the other side, you often get acrimonious, very often landlords, but creditors generally, who aren't prepared to work with and are determined to work against, and that lands up in the courts. But you've got to have pretty strong grounds for claiming that, you know, the entire rescue must be set aside and go into liquidation when you've got something that's been going on for 2 years. Now, a situation like Group 5, as I said, I don't know the detail of it, but Group 5 was a fairly massive group of companies, not all of which are in rescue. They had various different types of businesses. So time on that sort of business is not a quick 25-day exercise to get that rescue done. So, as I say, don't know the facts, but I imagine, knowing the practitioners involved there, that they are working hard to get this thing done properly. So it'll be interesting to see how this thing turns out. But please do take advice. COBRA will give you that advice, legal or from a practitioner, as to what your rights are if you feel aggrieved. You haven't been kept informed, you haven't been given information, you don't know what the hell's going on, and you're an affected person. You have rights, either as an employee or as a creditor or shareholder for that matter. And I've had one where the shareholders have been kept in the dark of what was going on. The other important thing to remember is that, as Marie said, unless people have been laid off in terms of Section 189, including directors. Remember, directors are in a company as directors in terms of the Companies Act, their fiduciary duties. They're also affected by the Labour Relations Act because they're employees. I'm talking about executive directors here. They're employees of the company, and very often they've lent money to the company as well, and often are also the shareholder. So they have very different hats to wear at any one time, and some of those hats will allow them to bring court proceedings, action against the company for forcing the practitioner to rectify the wrongs of the past.
Peter, maybe I can just jump in there on the Group 5 story. It appears that the creditors are taking exception with acts that were performed by the company before the business rescue commenced. So, with guarantees that were made and payments that were issued and payments that were made before business rescue actually commenced. So they're not taking exception with the practitioners, but it seems they want to, my assumption, and I only read part of one of the articles that was published yesterday following the application. My assumption is that they would probably be looking to put into liquidation in order to have those payments and guarantees declared void.
Well, that triggers an interesting point there, Ian, because what we've got to remember is these two provisions in the Insolvency Act, which have been carried through into the New Companies Act. That's a provision about undue preference and voidable transactions, and liquidators always have an eye open for those. Undue preference is, before going into liquidation, I paid my brother-in-law his loan back and then applied for liquidation, and the liquidator will have that transaction set aside because it gave undue preference to my brother-in-law rather than the broader church of creditors. And voidable transaction is one where there's been something that's been undertaken by the company which is voidable on the basis of it was illegal at the time. So either, you know, the law wasn't complied with. I mean, a classic would be you sold off a subsidiary of the company, or an asset of the company. You sold off the trade of the business and then gone into liquidation. You didn't advertise it as required you to do in terms of the Insolvency Act, etc. So you've breached the law in some way. That would be classed as an avoidable transaction. Now, both of those, the practitioner is required to look out for them, but the practitioner has far lesser investigative powers than an insolvency, than a liquidator. A liquidator has the power to summons. A practitioner doesn't. A practitioner, if he finds something that's been done that shouldn't have been done, some illegal, very often SARS comes into the picture. You know, we've underdeclared our taxes in the past, etc. The practitioner is required to, first of all, investigate it. He then is required to instruct management to desist from whatever they've been doing. And then he's required to report that to the, and I think the Act's terms are the relevant authority, not defined. I've known practitioners to go down to the local police station and make a report, and knowing that that's not going to go any further, which is inappropriate. If it is affecting SARS, then Ian and I would certainly approach SARS and begin negotiation with them about how to rectify the issue. I've done one that companies that fall under the that are FSP, so they fall under FICA, and in that instance, you'd have to report it to what is now the FSCA, used to be the FSB. So, you know, you must be practical on this and report it, but that's where it stops. You don't have to do a forensic audit. You don't have to investigate deeply unless you believe, and this is an important point, unless the practitioner believes that there's some money at the end of that action. Because if you think you can get some money back from such as avoidable transaction or undue preference, which will be for the benefit of the broader church of creditors, then one should do so. But if that is the case with Group 5, then obviously the creditors have realized that they're going to be worse off in a business rescue because there might have been some assets available which have now been alienated by way of issuing security over them or whatever. And if you have those transactions set aside by a liquidator, you could well be better off.
And on that score, let me ask Ian, again in the context of Group 5, I'm going to read to you a passage from a MoneyWeb article. But before I do, you're quite right. I had a look at the headlines. This has absolutely nothing to do with the conduct of the business rescue practitioners. It appears to be commercially related in relation to the security and resolutions that they contend are invalid. So to read this to you, on successful completion of the business rescue plan, secured creditors are expected to receive a distribution of between 66 rands and 78 cents in the rand, compared with 18 cents forecast in a liquidation. Concurrent creditors are expected to receive distributions of between 9 cents and 20 cents in the rand, compared with 3.4 cents forecast in a liquidation. What's that all about, Ian?
So, Maurice, every business rescue plan has to envisage a better return to creditors than they would get in a liquidation scenario, as we've already explained. But a business rescue plan would typically include, or has to include by law, a liquidation calculation, which is typically the business rescue practitioner will put together a liquidation and distribution account, a demonstrative liquidation and distribution account to show what creditors would get in a liquidation scenario, what both secured creditors would get, and what unsecured creditors would get. And in order for the business rescue plan to be acceptable and adopted by the creditors in the meeting to vote on the plan, it is obviously important that the business rescue practitioners show that in business rescue, the creditors are going to get a substantially better dividend or better return than they would get in a liquidation scenario. And that's what the Group 5 business rescue practitioners, the numbers that are quoted in that article are obviously what have been taken out of the plan. So yes, that is probably the most important part of every business rescue plan, showing the comparison between what the creditors will get in a business rescue versus in a liquidation.
We have a question by Elton. Thank you very much. Are business rescues undertaken when a creditor or a debtor is a foreign-based business and/or person? Does RSA law apply or international law apply? So the law in relation to business rescue, Section 129 of the Companies Act, applies to local companies and close corporations. Does not apply to companies that are registered in foreign jurisdictions. The foreign law would apply to those entities, but those entities would be domiciled outside of South Africa. Insofar as sole proprietorships are concerned, it does not apply nor to partnerships nor to trusts. That, however, doesn't mean that an informal turnaround process cannot take place. It is for that reason that COBRA takes on anybody. It's any business, because the only distinction between a company, as far as COBRA is concerned, a company and a sole proprietor, is that the company has the benefit of certain provisions that COBRA hopes will not be implemented, will do everything in their power to avoid the business rescue. I hope that answers that. We're almost done, but I was hoping that you'd be able to take us through the dynamics, Ian, that one finds between directors and shareholders, and malfeasance and the concerns that arise. Often business owners are loath to go into business rescue because they want to know, well, what happens when a business rescue practitioner comes in and finds that they've been undeclaring their income? What then, Ian?
Well, Maurice, as Peter explained, the business rescue practitioner is under a legal obligation to report to the relevant authorities when he's uncovered some form of malfeasance or a law being broken, and the relevant authorities in the case of under-declaring income is typically staff. So the practical implications of this is that we would approach staff, and we would, having discussed it with the directors and the shareholders, we would approach staff. We would declare the income that has been underpaid, but in practical terms, creditors typically are compromised in a business rescue scenario. In other words, they take a haircut. So we would negotiate something with SARS that works for the company and will allow the business rescue to work. Remember, SARS is not there to liquidate companies, and part of the mandate is to protect jobs and so on. They are not there to put directors into jail either. They are aware of the fact that a lot of companies, especially those companies in distress, may have been prone to under-declaring their income. So what we would typically do, approach SARS, let them know of the extent to which the income has been under-declared, and then negotiate something with them, negotiate a compromise with them that will allow the company to carry on trading and for the business rescue to be successful. The relationship between the directors and the business rescue practitioner is always an interesting one, and it's always one that we try our very best to work with the directors in every business rescue that we're involved in. The practical implications are that perhaps 1 in 10 business rescues that we do, historically, Peter and I have historically done, there's been some sort of breakdown in trust between us and the directors. That we try to avoid that at all costs. And when I say a breakdown in trust, it normally happens when there's directors are withholding information from us, as the case may be. We always try very hard to get the directors to be completely transparent with us, to let us know exactly what's going on in the company, what's led up to financial distress. We always say to them, we give them the opportunity to wipe the slate clean, and to start working with us in the way that we need, in a constructive way, in the way that we need them to work with us in order for the business to succeed. But historically, 1 in 10 times that doesn't work out, and then we either need to consider liquidation, or we need to simply wind the company down under a business rescue. Because to return a company to a solvent going concern when there is no trust between the business rescue practitioner and directors is almost impossible, as you can imagine. And just from the director's standpoint, it is very important for them to appoint a business rescue practitioner who has got a solid track record, who is known in the industry, who is reputable, who has not done anything in the past to compromise his relationship with key creditors such as the banks, because the relationship with the key creditors, especially the banks, the providers of debt, is critical in order for a business rescue plan to succeed, in order to raise post-commencement finance and that sort of thing. So, yeah, the relationship between the business rescue practitioner and directors is one that needs to be very, very carefully managed. And any breakdown can most of the time result in a business rescue plan not succeeding, or in the necessity for the business rescue practitioner to wind the company down under business rescue or to liquidate it.
Great, thanks. Very, very briefly, Peter, you'll see on the screen we have a PowerPoint slide detailing certain claims against the company by certain different categories of affected people. And we have shareholders, we have directors, we have employees, and we have trade creditors. And what's to be noted here is the trade creditors are only sitting at 10,000 Rand. So when it comes to the question of the plan, what happens with the voting? Can the shareholders and the directors who owed the most force the plan through? Very, very briefly, we've only got 2 minutes. Peter?
Very importantly, you'd have to pay these creditors off. They have an unequal say in the plan, because they are in this category together with the employees, classed as independent. So you've got 3 million of connected parties, shareholders and directors. So you remember what I said earlier, you need 75% to vote yes, but of the total voting, so if 100 are voting, 75 have said yes, 50 Rand have got to have been independent. Here, that would be impossible to achieve if that 10,000 of creditors was being obstructive. The best way would be for the shareholders and or directors to buy out those creditors, buy their claims, and work with the practitioner to get the plan resolved.
Fantastic. Thank you so much. That's a wrap for today. We have other webinars. We call them targeted webinars, specific webinars this week. And we've got some great ones. Tomorrow, we've got Gigi Alcock, who's dealing with Casonomics, the Casonomic Revolution, COVID-19. He's a renowned author, and he's been on the show before. Very, very popular. It's worthwhile watching. He deals with the informal sectors and what's going on in the ground there. So it'll be good to hear from him. That's tomorrow at 10. Then on Friday, we have how to best raise capital in the mid-market. Lessons learned by New Capital. New Capital will be presenting that. Again, extremely insightful, so don't miss that. That's at 10 o'clock. And then at 3 o'clock on Friday, we have Sifiso from IQ Business. Sifiso is an economist, and he gives us his weekly wrap-up. He reflects on the week, and he gives us very, very important insights. So that's it for today. Thank you to the attendees. Thank you to my co-panelists for joining us today. Until tomorrow, thank you and goodbye.